Good afternoon, everybody. This afternoon, Alice and I are going to be talking to you about the recent Law Commission report on Employment Tribunal Reform. This report came out in April and has got some quite dramatic proposals in it, which two of which we will look at in more detail. But let me start by just putting the whole thing in context. This was a consultative process. There were 72 groups or individuals that contributed to the report, and it produced some quite lively discussion and debate. We also had input from participants in Northern Ireland and Scotland, which was interesting, as the changes proposed will apply only to England and Wales. However, the Law Commission accepted those inputs because, of course, particularly in the case of Scotland, it's quite important that there's a buy-in to any changes that are made to keep the two systems more or less in line. I mean, goodness knows, those of you that actually do work in Scotland will know that there are significant differences between the way a Scottish tribunal is run and the way one is run in England and Wales. But it was thought important to get a buy-in from Scotland to get some degree of uniformity and, of course, to stop forum shopping. Anyway, so the interesting thing about the report was that right from the start, the Commission wanted to emphasise the uniqueness, really, of the Employment Tribunal system. They particularly mentioned the fact that the claimants within this system were readily identifiable. They were nearly always employees or workers. It's a no costs regime. That again makes it unusual. And of course, the rules or lack of them on the admissibility of evidence, again, makes the Employment Tribunal system quite unusual. Of course, regard is paid to the CPR, but there is no CPR for evidence in employment tribunals. But the Law Commission was anxious that those unique characteristics should be maintained. So what they were looking at particularly was the jurisdiction of the employment tribunals. And one of the points that we're not going to be looking at today, and which I'll deal with now very briefly, was the idea of concurrent jurisdiction. Those of you that work in employment tribunals a lot will know that employment-related discrimination matters are dealt with in the employment tribunal, but non-employment discrimination matters are dealt with in the county court. And there has been a lingering concern that there is a lack of experience and expertise in the county court when dealing with these discrimination matters. There was a fair amount of contribution on this, and our own Employment Lawyers Association made an interesting contribution, which was that they supported concurrent legislation, i.e. that both courts could consider both types of discrimination claim, but only as a preliminary step to establishing an Equalities and Discrimination Court that stands alone. None of these suggestions were in fact followed up on because it was felt that the employment tribunal system was already pretty stretched. But one proposal that did come out of considerations and debate with the participants was that employment judges experienced in discrimination matters should and could and should be cross-ticketed to sit in the county court to hear non-employment discrimination claims. And I hear a sigh across the ether as we all realise what that means for us employment practitioners, because it means that we will have even less of a judicial resource available to us should this in fact come to pass. But anyway, that is the proposal. As I said, the terms of reference focus very much on jurisdiction, and there are two main areas that we are going to be looking at. One is the question of time limits, and their extension, which is what Alice is going to be talking to you about in a moment. And the other is a pretty mammoth change in terms of the extension of the tribunal's jurisdiction. So I think, having said that, I'll hand over to Alice, who's going to talk to you about time limits and their extensions and the proposals that relate to those. Alice.
Thank you, Victoria. What I'm going to do then is to give you a brief overview of the current position on time limits for employment claims, and then address the Commission proposal for two significant changes to that position and what impact this is likely to have on claims. So first then, the current position. At present, as I'm sure you'll all be aware, there is no universally applicable standard time limit for claims to be brought in the Employment Tribunal. The majority of claims have a 3-month time limit, including in particular discrimination claims under the Equality Act and unfair dismissal claims under the Employment Rights Act. There are a few exceptions to that, claims which have a longer limitation period of 6 months, such as equal pay claims and redundancy pay claims. But those are very much the exception to the general rule of a 3-month time limit. And of course, each of those time limits is subject to extension to reflect the early conciliation period. Importantly, there are also 2 different tests applied by the tribunal when determining whether to extend the time limit when a claim has been brought out of time. Again, you'll be very familiar with them both. The first is the Just and Equitable Test, and this applies, for example, for claims under the Equality Act. It provides that a complaint may not be brought beyond the period of 3 months or such other period as the Employment Tribunal thinks just and equitable. The second test is the Reasonably Practicable Test, and that applies, for example, to unfair dismissal claims. It provides that the tribunal shall not consider the complaint unless first the claimant can prove that it is not reasonably practicable for the claim to have been presented within the primary 3-month limitation period. And secondly, the claimant must then prove that the claim was brought within such further period as the tribunal considers reasonable. In practice, as those who've dealt with these kinds of applications will know, the first of these tests is much easier for claimants to overcome. The Law Commission's proposal for change, then, is twofold. Its first proposal is that time limits for all employment tribunal claims should be 6 months, and that means, in practice, an extension of 3 months of the time limit for most claims. The Commission noted that a substantial majority of consultees were in favour of this, and explained that bringing a claim within this period of 3 months may be difficult, and that's particularly the case where there's a wish to pursue internal grievance procedures or a need to obtain legal advice and representation. And the Commission's view was that an extension to 6 months for all employment tribunal claims would strike an appropriate balance between facilitating access to justice for employees and yet still providing certainty for both parties, which is part of the reason why there has always been quite a short time limit for claims in the tribunals compared to in the civil courts. So that's the first change that the Commission proposes. The second is in relation to the test for extending time limits. And here, a very significant majority, 2/3 of the consultees, favoured changing the law so that all claims would now be subject to the Just and Equitable Test rather than the Not Reasonably Practicable Test. There were a few who opposed this on the basis that the Just and Equitable Test leaves more room for subjectivity and that could exacerbate uncertainty for the parties. However, the Commission took a contrary view and effectively considered that it was the Not Reasonably Practicable Test that risked producing arbitrary and unjust outcomes and preventing some deserving cases from proceeding. The Commission also noted that whilst the Tribunal does have a broad discretion in applying the Just and Equitable Test, this is fettered by parameters that have been established in the case law, and the test is sufficiently flexible to allow a variety of factors to be considered, and that of course includes the balance of prejudice to both parties and not just to the claimant. These are changes that will have a significant impact, and in particular, the change to the just and equitable test for extension, which is much more generous and allows more factors to be taken into account. There are also specific areas where the two tests had diverged in the authorities. For example, where delay in presenting a claim is attributable to incorrect legal advice from the claimant's solicitor. Under the not reasonably practicable test, the court has held that if the claim form was presented late through the default of a legal advisor, the tribunal would consider that it had been reasonably practicable for the claim to be presented in time, and therefore time would not be extended. By contrast, under the just and equitable test, the Employment Appeal Tribunal has held that where the late presentation of a claim form is due to incorrect advice from a legal advisor, the claimant should not automatically be refused an extension of time, simply on the basis that they may have a valid claim in negligence against their solicitor, since this would confer a windfall on the respondent. Of course, it's not necessarily the case under that test that time should be extended, but unlike the not reasonably practicable test, it's not ruled out. In scenarios like this then, and many more, there will be a greater opportunity for claimants to obtain an extension of time under the new proposed test. However, although this will broaden the scope for extensions, the same restrictions and principles which have been set out in existing cases in relation to the just and equitable test will still apply. And that includes, for example, the fact that there's no presumption in favour of the extension of time, and that the onus is on the claimant to convince the tribunal that it is just and equitable to extend time. And in the context that time limits in employment cases are intended to apply strictly, that is an important factor. Although in a case that followed that principle in Robertson and Bexley Community Centre, which I'm sure you'll all be familiar with, in the case of Caston, the Court of Appeal subsequently noted that those comments merely indicated that there was a broad discretion. The starting point in all such applications is and remains that it is the claimant's burden to satisfy the tribunal why time should be extended. And logically here, if both proposed changes are made and claimants have already had the benefit of a 6-month limitation period, it's likely to be much more of an uphill struggle for them to demonstrate why it is said to be just and equitable to further extend time. So in some ways, taking those two together, although there is a less strict test, it will be harder for claimants to satisfy it. And again, although it's not mandatory for them to do so, when considering an application for an extension under the just and equitable test, tribunals will usually consider, by analogy, the checklist of factors listed in Section 33 of the Limitation Act, 1980. And these factors include the length of and reasons for delay, the extent to which the delay will render the evidence less cogent, the conduct of the defendant after the cause of action arose, duration of any disability, acting promptly and reasonably, and taking steps to obtain advice. And that will continue to provide a framework and very helpful parameters for such an application to be considered and to guide the tribunal's broad discretion. In particular, where there is a significant delay and a lengthy extension sought, that will always be a factor taken into consideration, and the prejudice that will be suffered by an employer if the claim is permitted to proceed. So key arguments can, of course, still be relied on. So in summary then, the proposed changes, particularly when taken together, are likely to have a significantly beneficial impact on claimants, resulting in far fewer claims being successfully struck out on the grounds of limitation. It's likely, first of all, that fewer will be brought out of time, and secondly, there'll be a much broader discretion in many claims for the tribunal to grant an extension where there are grounds to do so. More claims are therefore likely to proceed to a full substantive hearing, which will have an impact on those representing both claimants and respondents.
Yes. Now, Alice, listening to that, one of the questions that's been raised, and it's really a point or a comment, is that that change seems to really only favour the claimant and does very little for the respondent. What's your view on that?
Well, Victoria, I agree. It's a change that will mean many more claims proceed as they can't be struck out on the grounds of limitation. However, that's not to say there won't be any benefits for employers and respondents who are dealing with such claims. The 3-month time limit now often results in claimants bringing hurried and poorly drafted claims when they haven't had the time to seek proper assistance or representation or clarify in their own minds what it is that they wish to challenge. One benefit of the extended time limit may be that employees who have time to properly consider their claims will bring clearer and better particularised claims, and that may, in the long run, save time and costs of applications for further and better particulars, applications to amend responses, and hearings which are required solely to clarify the issues between the parties. So in some ways, there's likely to be a practical benefit for employers and respondents too. And Victoria, another question which we've been asked in relation to this area in particular, in light of the extension of time, is whether employees will now be expected to await the result of internal grievance procedures before they issue a claim. What are your thoughts on that?
Yes, in the past it has, and I believe it will continue to be, but more so, that tribunals have been less sympathetic to claims out of time because a claimant has stated that they were waiting for the outcome of a grievance or an appeal. The feeling has been within the tribunals that a claim should be raised within 3 months of the act complained of, whether it be a termination or a discriminatory act. And then if there's any amendment required, that will have to happen later. One of the cases, again, that I'm sure you'll be familiar with is the Apologon Gabriels against Lambeth Council, which really typified that point. However, the reality is now that if there is going to be a 6-month limitation period, I think it is far more likely that a claimant can legitimately wait until either a grievance or an appeal has been heard, so that, again, it's only one claim that has to go in, as opposed to an initial claim with leave to amend being requested, should the outcome not be in their favour. Now, one claim can go in, okay, it will probably be towards the end of the limitation period, but at least it will be the complete claim, which will be of a benefit to both the claimant and the respondent. And let's face it, any company worth its salt really ought to be able to get a grievance and an appeal sorted out within 6 months of the act complained of. I think, quite frankly, if they don't, that's going to raise a question mark in the tribunal. So yes, I think there will be an expectation that these matters can be resolved so that a full and final claim can be put in when it is finally lodged.
That makes a lot of sense to me, Victoria. I think you're now going to tell us about the changes that the Commission is proposing in relation to the extension of jurisdiction.
Yes. Yes. Now, these are changes that I personally think are quite exciting, mainly because they deal with a piece of legislation that's quite elderly now. That is the Employment Tribunal's Extension of Jurisdiction Order of 1994, and I don't think it's been looked at since then. Just to recap, you will recall that this is a little add-on piece of legislation that allows claimants to make a breach of contract claim when they are making an ordinary tribunal claim. It's not they cannot be standalone claims. They are parasitic on an employment tribunal claim, but it allows for this breach of contract claim to be made on matters that are arising out of or outstanding at the time of termination. So there's the presumption there that they are only made in cases where there's been a termination of employment for whatever reason. They are limited as to the value, in that they're set at £25,000, and that's the value they were set at in 1994. So they have steadily decreased in value. And they are subject to certain exclusions. To explain, first of all, what is permitted is any claim that could be litigated in the county court. But what is not permitted is claims that relate to provision of accommodation, claims that relate to restrictive covenant or breach of confidentiality matters, intellectual property matters, and personal injury claims, obviously accepting the type of personal injury claim that we get from the Sheriff and Klein Tugs type of personal injury claim in a discrimination case. So that's the state of affairs that we have at the moment. The employers can, of course, also mount what is in effect a counterclaim. They're called employers' contract claims, but they are a counterclaim by any other name. Now, the Commission looked at this in great detail, and this caused probably the most lively and, can I put it, full and frank exchange of views of the consultees, because what in fact has been proposed is as follows. Firstly, given that the Employment Tribunal is used to dealing with high value claims, I mean, let's face it, some discrimination claims go well into six figures, it was felt that it was appropriate to up the ante on the extension of jurisdiction order to £100,000. Well, that caused a communal raising of eyebrows amongst the consultees, but the Commission felt that an increase in value was called for in any event, if only to account for the rising inflation, but also that there should be some kind of interface with the civil court system. Now, the threshold for claims to the High Court is £100,000, and it was that informed the Commission, because it was felt that here was an opportunity to allow employee claims without having the need to go to the county court. Of course, there are going to be claims that go above 100,000, and they would have to go to the High Court anyway. But that was the rationale. There was concern that because it's a no-cost regime, there would be unmeritorious litigation. But again, this is countered by the view that the small claims system doesn't seem to suffer from this problem, so it was thought unlikely that this would be a problem for the Employment Tribunal. They are used to dealing with these figures, and so that is the proposal. So that's proposal number one, £100,000 cap. The second proposal, even more dramatic, is that the time limitations on when the claim or what the claim can relate to should be changed, so that now the proposal is that a claim can be made during employment, at termination, and in fact after termination, both in terms of a matter that arises as a result of termination but continues on beyond, or one where the liability arises post-termination. And again, the Commission felt that the Tribunal was well used to dealing with these insofar as it deals with post-termination discrimination claims. Strangely enough, that proposal did not meet with very much objection from the consultees, who felt that made sense. So that's proposal number two. that breach of contract claims can in effect be made really at any time during or after employment. Of course, with the 6-month limitation limit, what that means is that for a claim during employment, the claim must be made within 6 months of the act complained of. For a claim on a matter that arises or is outstanding at termination, the claim must be made 6 months after termination. And for a claim that arises after termination, the claim must be made within 6 months of the liability arising. That's quite an important point. So that's big change number 2. Big change number 3 is on the exclusions. While the Commission, and again, this was almost universally agreed upon by the consultees, while the Commission felt that it was inappropriate for a tribunal to consider matters regarding restrictive covenants, intellectual property, or breach of confidentiality, mainly because the tribunal has no inherent jurisdiction to issue injunctions. And those of us that deal with those sort of cases know that a restrictive covenant case or an IP case, it nearly always involves some form of injunctive relief. And so it's just simply not appropriate for the tribunal to deal with it. Rather more messily, it was decided to leave the PI exclusion, personal injury exclusion, as it is, which I personally think is a bit of a shame because there are plenty of contractual benefits that revolve around personal injury that could quite legitimately be dealt with by the tribunal. But the general consensus was that it was best to leave it as it was, with these matters being dealt with by the county court or the high court, except of course for the discrimination type personal injury. The one exclusion that is now no longer an exclusion, it is an exclusion, is the question on provision of accommodation. Mainly because I believe that the Commission was very much affected or informed by the Qantas case. If you recall that was the airline staff who had to litigate in a number of fora to get some kind of remedy because they had straightforward Employment Rights Act claims, they had unfair dismissal claims, they had claims relating to the accommodation or the accommodation allowances with which they had been issued as part of their contractual entitlement. And those accommodation claims had to be litigated elsewhere. And it was felt that that just made no sense at all. And there is a certain synergy there between accommodation and employment, especially where you look at jobs that carry accommodation with them. So anyway, now the employment tribunals may consider claims relating to the provision of accommodation. But to me, the biggest change is that currently only employees are permitted to raise a breach of contract claim in the tribunal. The recommendation from the Commission is that this facility should be extended to workers. That is, people supplying a contract for service rather than a contract of service. Now again, those of us who swim in this particular pond will know that the difference between workers and employees is becoming more and more nuanced. And we're seeing employment tribunals litigating gig culture cases. And so it really is not entirely surprising that that workers should now be included, but of course that will require quite a serious legislative change. Of course, also that none of this applies to genuine self-employed people, Schedule D folk. And of course, the other thing that goes without saying is that everything that I've said about this also applies to the employer's contract claim, even the hike to 100,000. So those are the changes that are being proposed. I think they're quite dramatic, and I think they are going to change the way in which we employment practitioners have to operate within the Employment Tribunal. We are going to have to really raise our game a bit, because we're going to have to be looking at areas of employment that we have not looked at in the past. So that's those are the changes as they are proposed.
Thanks, Victoria, and I agree, there are clearly some very big changes proposed there. One of the changes that you mentioned is the proposal that tribunals will now be able to consider accommodation claims as part of breach of contract claims. You mentioned the Qantas claims, but one question we've had is what other sorts of claims are now likely to be brought in front of the tribunal that otherwise previously could not have been?
Yes, living as I do in a rural environment and being married to a farmer, I'm well aware that there is a large body of employees, particularly within the agricultural sector, that benefit from tied accommodation. But I'm also aware, because we get so many cases of these types of staff, of care workers, nannies, people who are required to live on the site where they work. They receive tied accommodation, and it is part of their remuneration. We get lots of claims from people like this, because they often tend to be quite low paid, and they tend to work very long hours, both of which tend to suggest that they are sort of subject or ripe for claims. What I'm not quite sure about is how the Employment Tribunal is going to handle this, because I guess that they are going to be looking at the value of that accommodation, whether that accommodation was lawfully or unlawfully or rightly or wrongly awarded or withdrawn. But I find it difficult to see that an employment tribunal will look at the reasonableness of charges as they relate to accommodation, or sort of additional rent or additional services charges. I can't see that being part of what a tribunal would look at. And of course, the Commission has airily said, right, accommodation is going to be included, but they haven't gone as far as saying to what extent. So I think that's going to be quite an interesting area, because we do get a lot of claims from people where accommodation is included in their remuneration. What I'm more interested in is the movement of the time of when such a claim can be made, because we've got claims now that are capable of being made during employment, and that's again a question that has been asked, is how is that going to work, and how's that going to affect the employment relationship? Alice, do you have a view on that?
Yes, thanks, Victoria. The report did consider, in broad terms, whether it's counterproductive to have an employee bringing a breach of contract claim while they're still employed. And there were some consultees who opposed the measure on the basis that that extension of jurisdiction would tend to damage employer-employee relationships. However, the majority were unanimous in supporting this, and the Commission noted that the exclusion of such claims at this stage really was quite anomalous when considering that the tribunal could otherwise consider breach of contract claims. It took the view that all such claims should be under the tribunal's jurisdiction. Importantly, allowing such claims to be brought without requiring prior termination of employment to the tribunal may result in a swifter resolution of the issues that have arisen, rather than allowing them to worsen to the stage of resignation or dismissal, and then a more extensive claim being brought in the tribunal, including the breach of contract claim. And of course, since the early conciliation process can be used when a claim is anticipated, the hope would be that many of the claims of that nature would never actually reach the tribunal because they could be resolved between the parties before that stage is reached. So I think it's an important concern, but actually there may be benefits in allowing this extension of jurisdiction for the relationship between the employer and the employee. And Victoria, this is another point that you've already discussed in your summary of the changes that are being made. But another question that we've had through is whether there will really be a significant practical impact if the limit for contract claims brought in the Employment Tribunal is lifted to £100,000, given that such claims can already be brought in High Court. You touched on that point already, but what are your thoughts on that issue?
Yeah, I actually think that this is probably going to be the most dramatic and most interesting change, because the situation we have currently, and again, those of us who deal with these sort of claims, you will know, what tends to happen is that if there is a significant breach of contract claim, a benefit, a valuable benefit that is estimated at being over the 25,000, there has to be such careful tiptoeing around the topic when drafting the Employment Tribunal claim to ensure that it is mentioned, but not to the extent that it in some way muddies the waters for a later county court or high court claim. Because what tends to happen is that if the claim is not drafted carefully enough, and then a later claim is made to the county or high court, an immediate application is made by the respondent on the basis of Henderson and Henderson that the matter has either it's a res judicata or an issue estoppel, the matter's been decided. It has been the subject of an employment of another court's judgment, and therefore should not be before the county court or the high court. And particularly litigants in person get themselves into all sorts of trouble with this. Of course, the very expensive claims are still going to end up with that difficulty, but the vast majority of claims, and I'm talking mainly about things like bonus claims or valuable benefit in kind claims, can now be litigated in the Employment Tribunal without having this awful situation of satellite litigation trying to decide whether the matter can go forward to the civil system. It can all be done in one court, which has got to be, I think, an advantage to all parties concerned. It just gives more certainty, and it's a tidier and neater way of managing matters. So while it's quite a big jump to 100,000, it isn't really, because that's the High Court limit. And the recommendation is, of course, that the extension of jurisdiction limit should be tied into the High Court threshold for that very reason, so that if nothing else, there's only two places where you can litigate these breach of contract, or you should litigate these breach of contract claims, either the Employment Tribunal if it's under 100,000, or the High Court if it's over. So a bit of tidying up, a bit of neatness there that I think will be of assistance to everyone. But yes, a very interesting point. But I think the reality is we're almost out of time. But there's one more question that we've had, which I think is a very valid one. And I'm going to ask you, Alice. How likely do we think that these proposals are going to be accepted?
I agree, Victoria, that is a very crucial question. And I think, as we discussed, it's very likely that all of these proposals will be accepted in due course and put into statute. as the Commission proposals in this area are usually accepted in full. However, these are changes that will require amendments to primary legislation, and with a backlog of legislation behind Brexit, further delays caused by lockdown to parliamentary time and availability, as well as the current need for additional time for everyone to queue and vote whilst distancing measures are in place, finding parliamentary time to get these changes made may be a challenge. So it's really a watch this space, but we can expect these changes are likely to be made in due course.
Well, thank you very much, Alice. I think I agree with you on that. It definitely is watch this space. Don't get too excited about it just yet. But it's good to know the sort of things that are likely to be happening. Anyway, we are out of time. If there are any other questions that people have, please email them in, and we will we'll do our best to answer them. But in the meantime, can I thank you all for attending? I hope you found it interesting and useful. We certainly enjoyed doing it. And we wish you all a good day.
Thank you, Victoria, and thank you all.